those attorney-client interactions are the bread and butter of what we do. They establish the foundation of how we're going to proceed with respect to whether we're going to be retained, and if we're retained, how the case is going to proceed. My view is that I always want to be truthful, candid, and plain-spoken with my clients.
The law is often about difficult conversations, and those difficult conversations call for us to tell the truth, to tell the client sometimes that their position is difficult, sometimes that their position is untenable. But in being truthful and plain spoken, and in giving sometimes difficult but candid advice, we are at our best as lawyers. I enjoyed speaking with Tom Withers, a true giant in the legal profession and one of my favorite Georgia trial lawyers. And I hope you enjoy listening in on our conversation about many things, including lawyers in the media, how he began his career and developed a practice in complex criminal and civil litigation. And so, without further ado, I give you Tom Withers. Well, Tom Withers, how are you? It's so good to have you on the podcast.
I'm fine, Scott. Thank you very much for having me. I'm privileged to be chatting with you.
Yeah, it's so good to talk to you here. I know that we've done some cases together, and I've visited with you when I've been in Savannah, but it's really good to have you on here. Something that we've sort of talked about, where we've kind of been around the edges of it, but what's it like to practice law in Savannah, Georgia?
I think Savannah is a good jurisdiction in terms of both the civil and criminal trial practice. From a civil perspective, I do a lot of stuff in the federal courts. Historically, the federal courts have been difficult places, particularly in the Southern District of Georgia, to practice. And so I get a lot of referrals for federal civil matters. And we have what I would call good crime in the Southern District of Georgia and in the state system as well. And so we've been blessed to have a number of substantial matters, both in the federal and state systems.
So how much of your practice is civil? I always think of you in the criminal context, as those are the kind of cases that we work on together. But how does your practice break down in terms of civil and criminal?
You know, it depends kind of on the year or years, but probably 30 to 35% civil and the balance criminal. But, you know, it comes and goes. I guess you get your name in the paper more or in the media more in criminal matters than civil matters, but the majority would be consistently federal criminal matters and then civil trial practice as well.
What and the civil is that plaintiff's work? What kind of civil work are you doing in federal court?
A little bit of everything. I would say more on the defense side, though. But I have, over the years, had some good friends out of the Western District of Pennsylvania that I've partnered with on some civil class cases, class action matters, and we've had some pretty good success, including locally. I'm just the guy in those cases, though, that plows a straight line. They are the brains and brawn behind the cases.
What does it mean to plow a straight line? You're just kind of doing the yeoman's work out there?
Yep. Generally, I would be what's called liaison counsel, which is kind of like local counsel, and they're doing the yeoman share of the litigation.
And what kind of class actions are these? Are these mortgage cases, I think? Is that?
So back in, 08, 09, we were on the other side of the wave of the subprime mortgage cases, and we had a couple of those. More recently, within the last 4 or 5 years, we've done several data breach cases up in the Northern District of Georgia, including Home Depot, which is just on appeal to the 11th Circuit, and a couple of other those data breach type matters.
So data breach, this is like a big retailer or creditor whose database gets hacked and personal information is released.
That's exactly right. Yeah.
And then you represent as a class the people who are victims of that.
True. Yeah.
Okay. So let me back up, and I'm going to go way back here. I know that you were raised in Atlanta. How did you go about, and I know that you went to University of Georgia, I think, as an undergrad and in law school. Yeah. Tell me a little bit about the process or how it is that you sort of became a lawyer, and what made you become interested in becoming a lawyer?
Funny thing, I mean, my mother always used to say that I was good at arguing with people. My first love in terms of profession would have been NBA basketball, but it turns out my talent would not take me that far. So I had to fall back on some other manner of making a living. And I did play 1 year of basketball at the University of Georgia in 1975-76, but that was as far as my talent would take me. Went to law school and had the blessing to come to Savannah by happenstance and go to work with a firm that was then called Oliver Maynard Gray, and really was fortunate to practice with two guys that were exceptional lawyers, Bill Franklin and Greg Hodges. Greg still practices. Bill is retired, who tried a lot of cases, and they were really good trial lawyers. So I was kind of thrown into the mix, and tried my first case a couple of years out of law school, doing med-mal defense and other insurance defense, but mostly med-mal defense.
So I think you came out of law school, was it in '84, and then you were there at Oliver Maynard, 6 years or so?
Yep, that's exactly right. Another kind of looking through the retrospective scope, another one of the blessings in my life was I had the good fortune to practice at Oliver Maynard and Gray with Willie Moore, who in 1992, I think, got appointed by President Clinton to the United States District Court bench. But Willie had been a former U.S. attorney, and so he got me involved in a federal criminal matter in 1988 that trial, and it was an insurance fraud case, and prosecuted both by Maine Justice and the local U.S. Attorney's Office, and we were fortunate enough to have prevailed in that case and got not guilty verdicts at trial. The result of which led to an offer from the United States Attorney's Office to go to work for them.
So after you beat them in '88, they asked you to come on board.
That's true. Yeah.
What was federal? I mean, I guess, was this pre-guidelines 1988? I'm trying to remember.
So the guidelines, I guess, went into effect, I think, in November of '87. So that would have been right at the cusp of the sentencing guidelines.
What was your practice? I know you mentioned that you did medical malpractice defense, and I guess your first trial was a med mal defense. Is that right?
True. Yep.
What was litigation like? Or you mentioned that you had three people that you sort of credit with being mentors to you. I don't think you used that exact word, but you said essentially that. What are some of the
really true.
What are some of the big lessons you learned from them practicing with them when you first started out of law school?
One was to have the courage to try your case, and two was to prepare. They demonstrated to me how to put your case together. At that point in time was from a civil defense perspective, but in med-mal cases, those cases are well funded by the insurance companies, and they're well defended. You have very good experts. Back then it was on the other side of tort reform, and so you had a few more cases that were not so substantial. But the thing that I came away from practicing with Bill Franklin and Greg Hodges in terms of their, kind of watching them prepare was how diligent they were in preparation and their willingness to go into court and try their cases.
And that was the first thing. You said that first, courage to try the case, before preparation, and I know they're very important.
Yeah.
What do you think is distinctive? I mean, it for a non-lawyer who might hear this, you would think everybody has the courage to try the case, and so people that don't really know lawyers except for the news or, I guess, TV shows or whatever, would just assume that all we do is try cases.
Yeah.
Why does the courage to try the case? To me, that strikes me as a very distinctive thing, both in criminal and civil. But what do you mean by that? And do you think that's something that kind of has been lacking in litigation?
Well, I mean, I could compare. I could watch my then partners at Oliver Manuel Gray. I guess I was made a partner in 1988. But I could watch my partners be willing to go into court and try their case, and see in comparison some of the folks in the civil defense of those very cases who were not willing to try their case. And so it was a stark contrast where I could see certain lawyers who didn't have the wherewithal to, for whatever reason, to go in and try cases, and could match that with what I was actually seeing with respect to Greg and Bill and going in to try cases. And so I was expected, being raised up by them, I was expected to go into court and try my cases. And I think, in 2 years out of law school, I tried 4 cases in that first year, which would have been 1986, and so that's that's a great benefit to have learned that you got to be willing to try the case, and of course the client has to be informed about the various risks and benefits. Those were civil cases. I tried my first criminal case, that federal criminal matter, in 1998, but I think it was a case of actual innocence, and fortunately the jury saw the same.
I would imagine one of the benefits to the willingness to try the case is you get experience. I mean, I'm moving into more civil, later in my career, where I find myself, but having started out in doing nothing but criminal defense practice, I find that a lot of civil practitioners don't. I mean, I think probably my first year out of law school, I did more trial work than a lot of civil lawyers have done so far in their career who've been practicing as much as I do. So were you requiring skill from getting into the courtroom, or was it, I mean, did it give you a negotiating edge? What do you think the advantage of being able to, having the courage to try the case gave you as a civil practitioner?
Well, great question. So one of the things that I was able to learn at an early age is if you are willing to try your case and you're preparing your defense, that was civil defense against insurance defense, you're preparing defense like you're going to try your case, then it gives you a better outlook in terms of ultimately disposing of your case. And so that's one of the things that I've brought forth over the years. Be well prepared, and it's something that Ronald Reagan and the Cold War used to talk about peace through strength in terms of the old Soviet Union, and I think that attains to the practice of law. You are going to get your best result in terms of negotiation when you're the most well prepared to try your case. And so that's a lesson that I've brought forward over the years, and that I think I learned at a very young age legally.
Well, what were some of the things that, I mean, you mentioned Franklin and Hodges were diligent in the preparation of their trials. What do you think set them apart? And you know, I think everybody thinks that we're diligent, but what, you know, looking at what they would do, what are some things they would do that you sort of learn from when you say diligent? Sort of take me through, if you're Franklin or Hodges preparing for a trial, what are some things they would do? What did their preparation look like?
Great question. So I mean, from a practical perspective, how do you put your willingness to work hard into actual practice? A couple of things that right off the bat. One is prepare your client and then your experts back then, your experts in the civil arena for deposition testimony first. And so we would meet with our clients, our physician clients, and spend hours and hours and hours preparing them for their testimony, first at deposition and then at trial. What does that mean? That means going over the records so that you, as a lawyer, have a good idea of what those records say. And then the testimony of the physician breathes life into those records. That same willingness to review records and prepare your client then translates over into, first in my career, criminal prosecution, criminal defense in that one case, and criminal prosecution as a federal prosecutor. I would be completely happy as a AUSA with a box of documents, reviewing those with the FBI agent, and distilling down the hot documents that we thought we needed to have organized and learn from those documents what the essence of your case is. And so as a practical aspect, it would be knowing your documents and then preparing your witnesses to testify. And when we would go take opposing depositions, being really well prepared in terms of attacking, getting your opposing expert to express his or her opinions and then attacking those opinions.
Mm-hmm. So it sounds like, so when I hear preparation, I think about the lawyer sitting in the office and really kind of going over the documents, but there's a real component for you in preparation in getting your witnesses prepared.
Yep, no doubt about it. And Scott, I know you have had Denise DeLaRue on.
Yes, I have.
And Denise and I have worked very closely for the last 15 years or so, and her helping me with theories of defense in cases and working with my clients in terms of preparation of that client. And so, she has made me a better lawyer in terms of understanding, kind of distilling theories down and helping prepare my clients now in my current practice for trial, testimony, what have you.
And in terms of what it takes to prepare, what are some other things you saw from the lawyers when you first started practicing that you still incorporate in your trial preparation? Because I know that you talked a moment ago about kind of going over the records and preparing their testimony.
Yeah.
But in terms of what you do, what are some things that you still do that you learn from them?
Yep. So one of the things that I think Greg used to do was prepare a deposition outline, and so I have brought that forward so that when I am examining a opposing witness or conducting direct examination, I have kind of what over the years I have come to call kind of chapters of examination, and that really arises out of what I learned from them. So, it would go from something as simple as background information to then getting into education, conduct of the offense conduct, etc. So that I actually organize my both my cross and direct in terms of chapters of examination. In cross-examination, Scott, what I do is I organize each of those chapters are contained in a separate binder, so that I move from one folder to the next as I'm conducting that cross-examination, if that makes sense.
No, tell me. I think I understand, but tell me a little bit more about that. So, if I were to walk into a trial that you're doing, and let's just say you are defense counsel, and let's just say that the lead agent is on the stand or is about to be on the stand, and I'm going to be sitting at the table with you. Mm-hmm. Tell me what your materials look like, how they're organized, and if I were to kind of have a camera on your lapel, yep, what would I see?
So I'm going to have, let's say it's going to be the lead case agent in an IRS case. So I'll have 6 separate folders that are sitting in front of me, and each of those folders addresses a particular topic that I'm going to be cross-examining that witness on. And I will, this sounds bad that I still do this after almost 40 years of practice, but I will write out my questions that in a very careful manner that I want to ask, and I will have underneath that question in a separate ink. So I'll write the question in blue, and then I'll write in red the answer that I want to get out of that question, right? And if that agent has testified in front of the grand jury here in the Southern District of Georgia, you get that grand jury testimony as Jinx Act well in advance of trial. And I will, if that question has already been answered, I'll have the page and line designation that I will go to if I get a answer other than what I'm looking for. So I'll go through each of those folders, and when I finish one chapter, I'll close that folder and put it back on my desk, and then move to the next area that I'm going to cross-examine the witness on.
And you say 6 folders. Is there anything? That's
just an example. So I mean, it's however many different chapters I'm going to be cross-examining that witness on.
Okay, so you come in having written, and you're actually writing the question out. You're not doing an outline, but you've actually gone to the point of writing the question out that you're going to ask, and in separate or different colored ink, the answer that you anticipate, and then you also have cross-reference where to find, I guess, impeachment material or something like that.
Exactly right.
Okay, so that's how you come in preparing. Now, obviously, we are often surprised by what witnesses say on direct. What are you also doing as you're sitting at the table listening to the direct testimony to deal with things that are unanticipated that arise?
Yep. So, obviously things do come up. So while the witness is testifying, there are 2 things I do at trial. I take my trial notes in blue, except for the cross-examination that I'm going to ask that witness that comes up while the witness is testifying. I write that in red. And any issues that I think will merit motion for new trial, I write in red also. So I'll just write out kind of topics and then questions as the witness is testifying. Now, I do have to say that every lawyer does things in a different fashion. This is just what works for me. My partner, Craig Gillen, we have tried a couple of cases together. And, Craig's cross-examination notes are much more cryptic, and he has the ability to stand up and conduct a cross-examination where he's not looking at his notes. He's smart enough, intelligent enough to just, go with what the witness is saying and then be able to walk that witness down a line that ultimately the witness ends up agreeing with a lot of what Craig says. So this is the kind of chapter method has worked for me for decades, and I find it an effective way to conduct cross-examination. And by the way, one other thing I have started doing in the last 10 years is when I get a answer that's not consistent with what prior testimony or a FBI 302 or IRS report or whatever, again, I'll have that handy so I can either display it immediately for the jury or, in state court, you don't have to lay the foundation for cross-examination for prior inconsistent statement like you used to in Superior Court. And so, you'll bash that witness with the prior inconsistent statement just, right off the bat when they veer from what the earlier testimony was.
Are your trial files, and you've mentioned different colored ink, so obviously it sounds like these folders, when you open them up, they're handwritten, you have handwritten materials. How have you, over the years, changed the way have you changed the way you do your, are you doing a trial notebook? Are you doing, to what extent are you maintaining things in an electronic format when you go into court?
Yep. So I do, one of the things that I learned at Oliver Manor and Gray was the use of a trial notebook, and I still do that. But now my file, sits in a container directly in back of me, my trial file, instead of having a trial notebook. The trial notebook will mostly consist of the pleadings that are at issue and motions in limine and whatnot, jury charges and whatnot. And I maintain the course of trial in folders in a container or a box immediately in back of me as we're proceeding through trial.
And so when you say you're ready to display something, do you have an assistant that's helping you with that? Or tell me how you're doing your exhibits and your demonstratives and things like that.
Yeah. So I've used a company for the last 5 or 6, 7, 8 years out of Atlanta called, it's Bob Poston's is the principal, Poston. I think it's Legal Technology Consultants. And, I'll tell Bob we have, and I'll talk to the jury about this in opening statement. You're going to hear me talking to Bob, and Bob's going to be displaying exhibits, and I'll be asking him to call up exhibits. And so, if we're going to impeach somebody on, page 62 of the grand jury testimony, lines 12 through 14, we'll have that marked as 1C. He comes up with the numerical designations. And so I'll just tell Bob, pull up 1C, and that'll be, on my notes for cross-examination. That takes a lot of work and effort, but it's very, very effective to be able to either play a snippet or display a snippet while you're in trial. Now, if it's a less well-funded case, I use a fellow who used to be an IRS agent who does that for me. But I think it's important to be able to use those documents for cross-examination and hit the witness with their prior testimony or prior statement immediately during your cross-examination.
Well, so it sounds like you put a lot into making sure the demonstrative works in a way that's not distracting. And I'd like to talk a little bit more about that because I find reading a lot of trial transcripts as I do, it seems like, I mean, when I say more often than not, I mean invariably more often than not, almost overwhelmingly more often than not, whether it's a prosecutor or a civil plaintiff's lawyer or a defense attorney, it seems like it's in both civil and criminal. It seems like more often than not, when it comes time to play a video, display something on a courtroom presentation system, there's a problem. And, the jury gets dismissed or the judge gets frustrated. It seems like lawyers aren't doing enough, or they just don't understand the technology, or they don't bring someone in to help. And it seems like there's just about always a hiccup when it comes to that. What do you, I mean, and people just kind of laugh about it, but what do you think's going on with a jury, or what do you think the effect is? Because I know seems like you put a lot into making sure that stuff works when it's supposed to work.
Yeah, it's got to. And, so I would say two things or maybe three things with respect to that, Scott. One of the things that I see in depositions still is lawyers not making a sufficient record as to what the witness is reviewing. In civil depositions, you'll be sitting there and the depositions will just be a mess in terms of making an appropriate record. Oftentimes our cases are, and I guess most civil cases now are, document intensive, and I'll just see some cases where it's just a mess. So one, you have to be careful as a lawyer, both in civil and criminal matters, to make certain that you are articulating for the record what the witness is reviewing. And that's true for both civil and criminal cases.
Because it's easy it's easy to lose sight of the fact that even if it's a video deposition, it's easy. What the witness is looking at, and the witness knows what the witness is looking at, but you're doing this for someone else who doesn't know what both of you know. And I think, or it's easy just to not know just to lose sight of the fact that you're doing this for an audience.
Yeah, more importantly, in my view, you're doing this, you're conducting your examination in a civil deposition with an eye towards that witness's testimony at a trial, right? And so if you don't have your witness's testimony cabined to an exhibit or tied to an exhibit, then when you get to a trial and you're trying to tie that document to this witness, it's a mess. So you've got to be careful when you're conducting your depositions that it's apparent what the witness is referring to. And again, that's because what's the ultimate goal? The ultimate goal is the purpose of an effective use of that, either at that deposition, either at a trial or a mediation. I will say a couple of other things with respect to use of audiovisual or other demonstrative aids. You're always going to run into a technical issue, right? Even when I'm well prepared and Bob Poston, the AV guy, is well prepared, you'll still run into an issue. And so you've got to, instead of, looking disgusted and sitting there waiting for something to go on, you got to be willing to just move easily to the next topic or the next topic, and sometimes you might even lose that ability to effectively cross-examine a witness on that particular page or item. You just got to be able to move on so that the jury doesn't see you getting upset. Or, as you described, the trial going off the rails. You just can't do that. You got to be able to move on and do that effectively. And in order to conduct that examination in an effective manner, you and your AV person have to be on the same page. And so, what does that mean for me? That means that Bob and I have been over everything that I'm gonna talk about, and he knows the exact page and line, or the time stamp if it's a prior video or audio statement. He knows exactly what it is. Again, he's the one who will have labeled what that exhibit number is, but he'll have labeled on page 3 of my examination, fourth question down, I'm going to ask Nancy about her statement at page 9, lines 12 through 14, and he'll label that exhibit 1C or whatever. But and I'll tell the jury at the start of the trial, you'll hear Bob and I talking about these, and that's just the manner. I'll tell the jury that's just the manner in which we've organized our exhibits and our demonstrative aids, so that they know what's going on when I'm talking to him.
And one of the things that I don't know if this is just something that maybe less techie lawyers do, or lawyers who aren't comfortable do, but how do you balance the use of technology in court with against potentially the accusation, and maybe on the defense side we don't get this as much, but this notion that we're being too slick, or we're being too fancy. Do you is that something that you worry about, or is that something that you just think really isn't a thing, or how do you manage that, or is it something that you don't think we have to worry about if we're doing it right?
Yeah, I mean, I don't worry about that. I want the jury to believe that we are well organized and well prepared, and I think it brings another level to your ability to effectively present your case if you properly use audiovisual or demonstrative aids during the conduct of your trial.
And how much do you use? And it may vary depending on the case, obviously, but on average, how much use of demonstratives are you using in your opening and closings?
So not much in openings. In closings, I will either have Bob or someone else, either inside or outside of the office, prepare or help me prepare the presentation for closing argument. So really not much in opening statement, and but a pretty good bit in closing arguments.
And I know you've mentioned Denise a moment ago, and her assistance in shaping themes and theories of the case. To me, if you're going to try a case, the use of a jury consultant, and at least doing some sort of a focus group, even if it's you're kind of on a shoestring budget, is so important. How much are you using Denise or someone like Denise? And I guess another question would be, how much do you? I've found Denise sometimes can be helpful, not only in preparing for trial, but in showing the client that a trial is a bad idea.
Well, that's true. I would have to say, in every trial I've had over the last 15 years, I have employed Denise for the purpose of trial preparation in some fashion. So I have convinced the client to help us out in that, to let her help us out in that respect, and I think it is effective. And so I would have to say consistently over the last years I've used Denise both for preparation of a client and for jury selection. Now, in some cases, she has reminded me that I'm nuts if I think I can try a case. So I went up to her office a couple of years ago in Atlanta on a weekend, and after listening to me talk about the defensibility of this case, she very candidly asked me if I was serious that I could try this case or not, and she's not quite that delicate.
Right. She's not.
So.
Well, so we were talking about the things you do in trial, the way you prepare for cross-examination, the use of demonstratives and getting help with that, and everything. And so in terms of, and that's in terms of just preparing, sometimes preparing for trial and executing in trial is the easy part. There are all kinds of things that sort of surround a trial, particularly in a high-profile case. Talk to me a little bit about cases you've done that are high-profile and some of the things you see that you see lawyers not doing so well when it comes to high-profile cases in the media.
Yeah. So I think a good and important issue for the legal community generally, Scott, so I'm glad you asked. My belief is that as lawyers, we should try our cases in the courtroom. And so as a general matter, the only statement that I will make prior to a verdict or prior to disposition of the case will be that we believe in and trust in the system of justice, particularly our jury system, and we are not going to try the case in the court of public opinion, but we'll do so in the courtroom. And that's it until the case is concluded, in my view. And so that's kind of a line we try to keep in mind in our cases.
Now, what do you do, though? It's not unusual in bigger cases, particularly if it's if there's a big cache of drugs that are found or something like that. It's not unusual to see law enforcement, that sort of, it's almost cliched that law enforcement with the big table of guns and drugs and money behind them, or to see prosecutors announce their indictment with a press conference or by inviting the media. Do you feel at all a need to respond to that in terms of your potential jury pool?
I do. So a couple of things in that respect. Recently, I have moved to dismiss an indictment based upon the press conference that the then United States Attorney held. That was probably a couple of years ago now. And so, I think there are things we can do, and that's one of them. And the other one is to send a letter to the prosecutive authority, whether it be a district attorney or the United States Attorney, and inform them they need to hew to the local rules in federal court and to the Georgia bar rules, which are very, very similar, and that we expect them to do so. And if they continue to fail in their duties, that we're going to take appropriate steps.
So you take that, whatever it is that you think is inappropriate or maybe inflammatory to your potential jurors, and you just even deal with that within the courtroom.
I'm not sure what you mean by that, but
okay.
So, recent case in Southern District of Georgia, and I don't want to get too much into the specifics because it's still pending, but the U.S. Attorney goes wildly off the rails in terms of what's permissible. And so I file a motion to sanction the government for failing to comply with not only the local rules, but it's codified in the CFR, how DOJ employees and assistant U.S. attorneys are supposed to, and U.S. attorneys are supposed to act, and how their conduct is supposed to be conducted. Poor way to phrase it, but those local rules and the CFR really is largely reflected in the state bar rules, and so we have been pretty, I think, tough but fair in informing the courts and the prosecuting authorities that we expect them to abide by the state bar rules, local rules, what have you.
Yeah, and I think what I meant by my question a minute ago is you don't feel the need to respond in kind. If there's a press conference, if the government or if the state is doing too much or using the media inappropriately, you don't feel the need so much to respond in kind with a press conference of your own. You trust in the system itself. You'll file a motion to try to deal with it and let the court address it. So even the step of your opponent going to the media in an inappropriate way, you feel like the best response is to deal with it through the legal system itself, through a motion or through writing a letter or something like that within the system.
That's exactly right, and we have done that, and I think that's the way. Now, the rules do allow you for a kind of tit for tat, the state bar rules and the local rules. So I have never done that, and I can think of only one occasion where my partner in Atlanta did that, and he did it successfully, by the way. But I think there are improperly using the press by prosecutive authorities is something that I take really very seriously, and I don't think that the system or our clients are served by getting out in front of the press and trying to sculpt things, as it were.
Well, I share your view on that. I take a dim view. I mean, I think the press, they're after a story. And generally, my experience is guilt sells better than innocence. And I think that only marginally so. I think the print media does a little bit of a better job than the broadcast media does.
Yeah.
But I would say only marginally. So knowing, or if we assume that trying to sculpt the case in the media doesn't work, why do you think so many of our colleagues are so anxious to try that or to try to get on TV and related to their cases?
I think a great question, Scott. I mean, I see it as the attorney's pursuit of 15 minutes of fame to the detriment of the client. And I feel really strongly about that. I can't recall a case as I sit here right now where an attorney has gotten in front of the cameras pre-trial and has made hay for his client in a positive manner. I just can't. I can't think of one. Maybe there's some out there, but I think that stuff has an ability to boomerang, and it's very difficult to control a narrative in a criminal case, particularly when you're at the beginning of the case and you don't know what the evidence is going to be. And so I see that as lawyers disserving their client's best interest.
In the interest of promoting their own, I suppose, their brand or their practice, or just because it's, I guess, fun for some people to be on TV, though I can't imagine what's fun about that. Really.
I think that's right. I mean, I think it's pursuit, it's selfish pursuit by an attorney of 15 minutes of fame, and you see it all the time and see it fail all the time. And in my view, the client is roundly disserved by the attorney's pursuit of his or her 15 minutes of fame.
Well, on a related note, what are your thoughts on and I see you on Twitter. You're not talking about your cases, but I see you talk about a number of things from, some you may retweet something that someone took a great photograph or something like that. What do you think the lawyers? What do you think about lawyers and social media and how we're doing it wrong and how you think we might be doing it right? And I say we very generally, not you and I
Yeah.
necessarily.
Well, so that's a complex question, but I think that for us, related to our law practice, we have to be very careful. And absent getting your client's consent, I don't think you can talk about your client's case except in the most abstract terms. I can't think of an instance where I've ever done it. There are state bar rules that govern your ability to talk about a client's case, and unless you've got your client's consent, you're treading on thin ice in that respect. Now, I know you're friends, acquaintances with Judge Dillard. I follow him on Twitter. He tries to use that platform for the educational purposes and transparency purposes for the courts, which I think is fantastic. I'm just really uncomfortable talking about a client's case on social media. I wouldn't do it unless the client gave me express permission, and I would do it very carefully under those circumstances.
Hmm. I think it's just a good place for lawyers to. I mean, it's almost like if you do it right, it's a good way to interact and be friendly with other lawyers just generally. But yes, I think when you come to the level of talking about, I think you have to even be careful just generally if you were frustrated by something that happened and you speak in the most generic terms. I don't think it takes a lot of work for someone to figure out what it is you're talking about sometimes too.
Yeah, yeah. There are specific rules that govern how we're supposed to conduct ourselves that apply to social media as well. And, I see attorneys on occasion talking about their cases, and I have, when they're friends of mine, I've sent them communications and said, hey, you need to be careful. Mm-hmm. But I often observe that and find it problematic, really.
So one other thing I would like to talk about, because we've talked generally about trial preparation and cross-examination. Now we've talked a little bit about the use of the media. And this is another topic outside the courtroom, and it's one of the things that I've struggled with. And so maybe I'm asking you this question for my own selfish purposes to try to learn from you. We all have the experience, whether it's in the civil or criminal realm, where we realize, maybe sometimes it's after getting the discovery and mm-hmm. sometimes it's after doing some witness interviews, that the case that we have mm-hmm. Is not the case that we thought we were going to have when we opened the file. It's not as was represented to us by the folks we talked to. Yeah. And I jokingly talked about Denise, how sometimes Denise's contribution can be to tell us, not necessarily a theme for the trial, but maybe you should reconsider trying this case at all. Yeah. And I find myself often in the situation where the client and I don't see the case the same way. Mm-hmm. The client's expectation, or maybe it's because of me, maybe because it's my past successes, or it's because, they have a lot of confidence in me. But the greatest lawyer can't undo the worst facts. No matter what, we're limited in the law and the facts that we have. How do you manage client expectations, and what are some things that you do to sort of, I suppose, help the client sometimes see reality of a case?
I think that's a great question, Scott. I really do. Because those attorney-client interactions are the bread and butter of what we do. They establish the foundation of how we're going to proceed with respect to whether we're going to be retained, and if we're retained, how the case is going to proceed. My view is that I always want to be truthful, candid, and plain spoken with my clients. So even, and I mean that from the outset too. So, certainly we've had cases that have turned as we've gotten into discovery, and, oftentimes as a lawyer, you're kind of wondering where this case is going, until you get the discovery. But even at the outset of a case, I will tell a client there are no guarantees other than I know what I'm doing and I work hard, but no guarantees in law or in life. So I just try to be very plain spoken and very candid with the clients, Scott. That with some clients, I know I've lost clients because of my unwillingness to kind of jump on the bandwagon at the beginning of a case. But in my view, that ability to communicate with the client plainly and truthfully is really a foundation of what we do. And so if I'm going to lose a client who doesn't like me to talk in frank fashion about the jeopardy that they're facing, then I think that's just the way it's going to be. In civil cases, I often ask, if I'm on the plaintiff side, what is your expectation with respect to what this case is going to do? Where we're going to be with this case. And I don't do a ton of civil stuff anymore, civil plaintiff stuff anymore. But it is always instructive to me to find out from the outset what the plaintiff's expectations are in a civil case, because if the plaintiff has a $10,000 case and they think it's $1 million case, then they're never going to be happy. And you're best served, in my view, to send that client on down the line. But in the criminal realm, I think that one of the things I do at the outset is write a letter to the client explaining to them what the charges are and what the potential penalties are. And that's in writing, so that the client has it there, can look at it and digest what their jeopardy is in a particular case.
So in terms of it's just being frank and plain spoken and truthful. So that is in terms of managing the client's expectations. Now, and that's in terms of potential results. Mm-hmm. Now we do also know that there's a lot of hurry up and wait in the law. So sure. Yeah. We if it's on appeal, we may be waiting for the court reporter, and if it's pretrial motions, we sometimes find ourselves in the place where we've argued the case to the court, and it may be a difficult decision, or it could be that the judges are just slammed and they have a lot to do. Yeah. There's a lot of waiting. And I find with some clients that there's no news to report, but clients want there to be news, and they call wanting news when there is none. How do you deal with the client's expectations regarding just the way a case is unfolding, or impatience about where things are going?
Yeah, so we're in a different world with COVID, right? And what I like to do, I can't say I do it in every case, but what I like to do is set out for the client a roadmap of how the case is going to progress. And the reason I do that, Scott, is because 25 years ago, my mother was very ill, and we were running around to this doctor and that doctor. And, the doctor would blow into the room, talk to you for 3 minutes, then out, and you have no other manner to communicate with them. Well, I try and make myself available, phone, in person, email, but I also want to have the client have something in his or her hand that they can look at for the purpose of, this is how this case is going to go. This is how the case is going to progress. Now with code, it's a little more difficult to predict because, a client could get arrested in January of 2022, but, who knows when the case will be indicted? Who knows when the case will potentially go to trial? And so, we're in an unknown in that respect in terms of, timing and continuity of the case. I just try and tell the clients today, literally, in today's world, we don't have the ability to use our experience to forecast when a case might come to trial or when a case might be decided.
Because we just don't know. We literally, I had a calendar call set for Monday that I just got an email that it's now been moved virtual and the jury trials for the term are off in this one particular circuit.
Yeah, and I've got several cases where they were indicted a couple of years ago. I would be surprised that they get reached this year, 2022, and they're a couple of years old already. And just because it's it's a different world and it's an unknown, and clients seem to be reasonably understanding with respect to that.
If they're out on bond in particular. Those not out on bond, it's a whole different thing.
Oh, gosh, I'll tell you what, people that are incarcerated during, surges of COVID in the jails, they'll get locked down 23 hours a day. Mm-hmm. And it's just awful. And I've actually used that to argue at sentencing that, if you've done 120 or 180 days in lockdown, then, that's like serving 3 years. I don't know what the equivalency is. I really don't. But, there's a pretty good bit of science out there about the deleterious effects of those types of lockdown.
Because it's essentially solitary confinement for everybody, and
it really is.
Yeah,
it really is. It's awful. I don't think that the courts have wrapped their minds around how difficult that has been and will be for the individual clients, individual defendants.
So, how's your practice changed over the course of COVID? Have there been some things that have improved for you, or?
Well, one of the benefits is doing these virtual arraignments, and at least here in Southeast Georgia, we have a lot of calendar calls where you'll go over, and the judge is just trying to get a sense. I had one yesterday here in Chatham County, and the judge is just trying to get a sense of what's on her docket and, how things are going to be progressing and what's, it's 30-something cases and, what's potential trial coming up. It's wonderful to be able to do those virtually. Because, you can put yourself on mute and continue to work. And then when your case gets called, turn on the video and unmute and spend the 5 minutes chatting with the judge about the case. Whereas in the past, you might have to drive to Statesboro, a couple of hours in the car, a couple of hours in court. And now you just are able to sit there and in your office. I think that's wonderful, and I hope that we adapt that going forward. I really do. I have not had a jury trial since COVID started, so I'm scheduled to have one next month, assuming that this most recent Omicron surge, continues to decline as it has in the last few days. I think that case will go forward. So I can't give you the benefit of my experience in terms of trying cases during COVID, but it's just been a pause both in federal and the state system in terms of the ability to get cases to trial. And as you say, if your client's out on bond, that's okay. Although people, if you've got a case, and I've got several where I think they will end in trials, then it's for the client, it's like having Damocles' sword over your head, but better to be out on bond, and that's manageable.
Habeas corpus and appeals have never moved faster. I mean, and I bet you state habeas corpus will never go back to the way it was, because there's no more trying to coordinate getting the lawyer representing the habeas petitioner and the attorney general and trial and appellate counsel in one room. I mean, all of that's been taken away. So I've found that habeas corpus has moved pretty fast.
Yeah,
and
that's fantastic.
And motions for new trial in the state system have moved very fast. So that seems to be. But I suppose one day there's going to be a gap, because the fact that we haven't had so many trials is probably going to catch up with us at some point. Which maybe that's a nice problem to have on the post conviction end.
Yeah, Scott, a year and a half ago, say summer of 2020, I was worried that there was going to be a tsunami of trials. If COVID was going to, end September 1 of 2020, and then everything was going to be back going full bore. And, it's obvious to, I think, all now that we have to be much more resilient in our scheduling, and that this is a problem that's going to plague the courts and DAs and defense counsel for years. I will say one thing that I have not seen from district attorneys' offices. Maybe it's happening, Scott, I don't see it, but that is the triage of cases and just throwing some cases overboard that don't need to be prosecuted even on the best day, but they're still proceeding apace like we were pre-COVID. I've got at least 2 cases under indictment right now that never needed to be indicted even on their best day. And I'm disappointed that the district attorney's offices are not taking a closer look at cases and understanding that triage needs to occur.
Well, I really appreciate having you on the podcast. And, if there's anything else you want to say to the listeners, please fire away.
I don't. I'm grateful, Scott, and privileged for the ability to chat with you. If anybody wants to ask any questions, I'm happy to answer them. And you can call me at the office, and that number is 912-447-8400, or shoot me an email, and that's available on my website.
Okay, Tom. Well, thanks so much.
Thanks, Scott. Take care.
Thanks for listening to The Advocate's Key. For more information and content like this, including a transcript of this episode, be sure to visit scottkeylaw.com, and please rate, review, and subscribe to this show wherever you get your audio content.